Hello and welcome to The Neutral Voice. I am Samung Deb Barma. This podcast is a space for conversations on how conflict is understood, experienced, and addressed, particularly in situations where legal, commercial, and human dimensions intersect. In this episode, we explore how disputes develop across these layers and what it takes to work with them in a way that leads to meaningful resolution. I am joined by Ms. Hagit Shaked-Gvili, a full-time ADR specialist and one of the early pioneers of mediation practice in Israel. With over 2 decades of experience, she has worked across a wide range of complex disputes, including multi party, cross cultural, and high stakes commercial matters, and has played a role in shaping how dispute resolution is approached within court systems. Her work brings together legal insight, structured processes, and a deep understanding of the human dynamics that sit within conflict. We're glad to have her with us today. Thank you for joining us, Ms. Hagit.
Thank you, Samung. It's my pleasure to join you today.
To begin, you have been working in dispute resolution for over 2 decades across a wide range of matters. When you look at disputes more broadly, what patterns tend to appear repeatedly?
I think that every disputes within the disputes that I deal with have three dimensions. The first dimension would be the legal disputes. Most of the disputes that I mediate are mediated with lawyers that are representing the clients, and they usually bring to the room the legal aspects of the disputes. And it's very important for the mediator to be knowledgeable of the legal system and the legal issues that rise out of the disputes, and be able to give the parties, the batna and whatna. It's quite popular phrases within a negotiation and dispute resolution, in order to understand their stakes if they do not succeed within the mediation and go to the alternative, which may be the court or arbitration. The second dimension would be the commercial aspects of the disputes. Sometimes you may have a very strong case, legal case, but the effect on the commercial arena may be very bad, and you do not want to get in there. So the media must ask the right questions to understand the commercial environment and to see what are the options that are out there for the disputes. And the third dimension is, of course, the human, emotional. We are dealing with people, and many times it is based on misunderstanding or people that are not working good with each other. So I would say that these are the three dimensions that are very crucial within the mediation process.
It's enlightening to hear about the 3 dimensions that you have mentioned. So, in many disputes, these three elements, the dimensions, be it legal, commercial, and emotional, they are at play. So, over your years of experience, which of these layers tend to drive the dispute the most?
I think that it's very hard to give one answer to this question because every dispute is different, and the professional mediator should at first analyze which dimension is the most crucial in the specific dispute, and then work toward resolution with giving the most attention to the specific dimension. Of course, there are many disputes where the three dimensions should be treated equally, but it's really something that is very hard to predict in advance. Some of the cases, when I prepare and I read the materials, it looks very easy. And when you get in the room, you see that, the people have a lot of past relationship that you need to figure out how to solve. And on the other hand, some cases that look really complicated, when you read the materials, when you get in the room and you see that the people really came with the intention to solve the problem, then within few hours we are with signed agreement, and the dispute is behind.
So, understanding the complexity of disputes, it's often that what is happening beneath the surface that may not be immediately visible to those who are involved in the dispute. So, is that something that you recognize frequently in your experience?
Yeah, I act as arbitrator and also as mediator. So, as an arbitrator, my side of the circumstances is really limited because I do not have the tool of mediation to meet with each party separately. And I would say that in over 90% of the cases, in those private sessions, there are hidden interests or hidden interactions that are not within the papers that we read before the mediation, and have really huge influence. I can give you a spicy example about a law firm that I mediated between the partners. They wanted separation, and presented the papers with all the numbers and the contract they had within each other, and it looked very simple to mediate it. And when I made a pre-mediation session, I understood that the partners are not even willing to meet with each other in the same room. They want to manage the mediation with the caucus, with the separate meetings without even seeing each other, because there was a personal relationship and affair between two of the partners that wanted to separate. This is something that you could not understand from reading the papers, but only talking to the people and understanding, the sensitivity of the situation and how to handle it.
Thank you. I think that brings a lot of light on what you can perceive through the papers and when you are actually sitting inside the room. So, thank you for sharing that example from your experience. So, when disputes involve ongoing relationships, whether business or personal, how does that influence the way the process unfolds?
Many of us have this romantic view of mediation about the parties that are continuing relationship and keep working together. But actually, I would say that in probably most of the cases, there is like one-time interaction, and the parties just want to separate and continue with their business life. Only in, I think, unfortunately, about 20 or 30% of the cases, you can see a continuing relationship, and sometimes the solution involves new deals or new contracts that some of them are compensating for the original dispute. And this is, of course, gives me as a mediator much more space for creative resolutions. But as I said, it's not very common. I mean, in most cases, commercial cases, the parties just want to settle the case and continue. Of course, that if we are talking about commercial arena that is very specific and small, there is an interest to keep the reputation and keep the relationship correct, if there will be any opportunity in the future for business cooperation. We can see in family cases or labor cases where the parties are definitely continuing their relationship, then we can see much more willingness to get to a solution because they're not really separating. They need to get to a solution with this specific matter and then continue as workers or as family members. So it's quite different than the commercial arena.
Okay, thank you for drawing that difference. So, the another thing that I want to ask is how does the way parties communicate with each other influence whether a dispute moves forward or remains unresolved?
No, in these times, many of the disputes are taking place online. The mediation. It may be good for certain disputes, and especially if we're talking about multicultural or disputes that are with people or companies that are from different countries. But maybe I'm a little bit old-fashioned with that. But I think that the face-to-face interaction is really irreplaceable because the eye contact, even the hormones that we are smelling each other, or the body language, it has more than 50% effect. So it really matters, the forum and the preparation of the people, who is coming for the mediation session. I think that if you have the right people with the right intention, you give the time to talk about the things, then more than 90% of the disputes are resolvable.
Thank you. So, as a follow up to what I have just asked, are there patterns of communication that you see repeatedly in your experience? I mean, that tend to escalate or stall the resolution.
I think that this is something that is really cultural. Israelis, for example, are known for being very direct people. So usually after 1 or 2 hours of the session, you will know what is in stake. With other cultures, it may take longer for the mediator to understand what is the problem. Some of the people, they will shout it out, and some of the people, it will take time before, they trust the process and the mediator and reveal the information that is really crucial for the resolution. So as I said, every dispute is different, and it's really hard to give like one rule for each. And I think that the most professional mediators. My mentor was Judge Daniel Weinstein, that you probably heard of, with the Weinstein International Fellowship. I'm senior fellow, and what I've learned from him is that you have to be very intuitive and to have a hybrid approach. I mean, to get into the room, to understand who are the people who you can work with, who is the decision maker. According to that, to continue in the process and understand what is the best way to get to a resolution.
Thank you. So, you are known for a structured yet also creative approach to dispute resolution. How do you adapt your process to suit different types of disputes and parties?
I think that the key would be preparation and cooperation with every person that is in the room. So I think that pre-mediation is very important to set the expectations of every party and understand, even within the technical things, the time frame, the budget, the people that are going to participate, and creativity is in every stage. I mean, if I see, for the example that I gave before, that people are not even willing to sit with each other, then I'm not going to be, rigid about it and say, no, I'm a mediator and I want everybody to sit in the same room for the opening session. And after that, you can do whatever you want. Okay. So if one party, I understand that he's going to feel much more comfortable and communicate better when he's in a separate session, then I can start with a separate session. If the parties want a certain person to be the one that is communicating with me, then I can do that. I mean, in Israel, it's very common, unlike in other regions, for the mediator to communicate directly with the disputed people. Okay, so many times I would talk to the attorney and I would say, I think that now it would be the best for the process for me to have a one-on-one session with your client. I promise you that he's not going to make any decision without consulting you. In most cases, they will trust me and give me the opportunity to speak directly to the clients. And many of the breakthroughs of the session would be in these one-on-one sessions. After we decide, the principles, we will go back to the room and give it the legal, backup. And of course, that the lawyers are part of of the session and are taking part of it and they influence it. But I think the real thing is to understand in every case what are the expectations, who are the people that can make the most influence on the process, and working with that in the most creative and efficient way that is possible within it.
Thank you. Uh, I just want to ask, like looking back across your experience in disputes involving multiple parties or interests, what becomes particularly important in managing the process effectively?
So with multi-party is going to be more, of course, challenging than just have like a two-party case. I think that you have to work with dispute system design, which is something that I specialize in. I worked with Professor Martinez from the Negotiation and Conflict Resolution Center in Stanford. It's connected to the law school and also to the business school. And I think that if you go with a dispute system design principles and you prepare the process in advance and with cooperation with the people involved, then it's going to be easier to handle it and to bring it through a resolution.
Just by way of quick example, without going into the specifics, what was the most like, challenging situation for you in your experience while sitting in a mediator's room or in arbitration?
So I think that the most complicated case that I has had 10 parties, 10 separate parties. Each one of them was represented by different lawyers. So we have a lot of interest in the room. Of course, that in this kind of cases, I work with usually with another mediator, sometimes a bigger team. It depends on the circumstances. But it was very challenging to identify the different interests and to lead to a resolution that will give the parties, not the best satisfaction that they were expected, maybe, but at least a resolution that they can live with. In this specific case, there was an event of a storm, and one of the rivers overflowed and made a huge huge damage to houses and also to commercial places. And we had to bring in insurance companies and the private people and some state authorities, all to get together and bring the solution for the best compensation that each party can get from this event, and also um, the solution, the final solution was to build the best practice for the future for this not to happen again. So that was one of the most challenging, but also very interesting and satisfying cases that I mediated.
Thank you. So, looking back across your experience from early work in code connected ADR to your current practice, what has most shaped your approach to resolving disputes?
I think that my career is very unique because I have the perspective from different angles. On the first years of my career, I was working for the courts. I started the first court annexed mediation program in the courts of Tel Aviv, so I know very well, how the judges work, what they need, and this is that was the basis. And then I worked within academy with Stanford and Bar Ilan University, so all the academic dimension of dispute resolution is also very very important. And of course the third part would be the practice. I met, I think, with thousands of people, hundreds of companies. So within the experience, the more you mediate, the more you have more experience, and you can be more confident in your practice.
So, lastly, before we close, what is something about conflict or dispute resolution that people tend to understand only through experience?
I think that most people have this thinking about when you have a dispute, you go to third party, you tell him the story, and you want him to decide for you. But actually, I think that the best resolution is when people are taking their destiny within their hands and coming with more proactive approach to resolution. I think that this is something that only after you participated in mediation, you can really understand the difference between going to a judge or an arbitrator and asking him to rule, or participate within mediation with professional mediator that is managing the process and leading you to the solution when you are active and you really give all the relevant information that will lead to the ideal solution. Within the circumstances, it's never ideal. You always have to compromise on something, but at least you know that you have the control over the process. When you have control over the outcome, and you can also save time and money and many time very important resources for your business or for your personal interaction, then I think that the value of it is really unbelievable.
Thank you so much, Ms. Hagit, for sharing your insights. It has come across as an addition to the rich conversations that we have been having. And we appreciate you taking the time to join us. And we look forward to continuing these conversations in the future episodes. So, to all our listeners, thank you for joining us. This has been The Neutral Voice.
Thank you, Samung. It was a pleasure to have this conversation with you, and good luck.
Likewise, Hagit. So before I stop the recording, just wanted to ask: is there anything else you would have liked to add in what we have talked so far?
I think that unfortunately, most of us live in an ego system where our egos are leading us to act in different ways, and when the people in the room in this moment, when they understand that there is something that is bigger than the self, maybe the company, maybe the community, I think this is the point where there is a pivot and the things are shifting towards ecosystem. I would call it. So from ecosystem to ecosystem, that should be the goal.